Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the Supreme Court verdict on tainted candidates or the Supreme Court's verdict on decriminalization of politics. Now if we look at the current affairs, in the month of September 2018, 5-judge bench of the Supreme Court said that it was not within the powers of the Supreme Court or the judiciary to disqualify politicians facing criminal cases from contesting elections. So with this judgment or the verdict of the Supreme Court was making it clear that disqualification of the politicians from facing criminal cases from contesting the elections were not within the ambit of the Supreme Court or the judiciary, but it was the legislature who is responsible, or the parliament that is responsible for making laws that will disqualify the politicians facing criminal cases from contesting the elections. Now if we look at a recent incident, Sadhvi Pragya Singh Thakur, a BJP candidate against Digvijaya Singh of Congress in Bhopal Lok Sabha constituency, has been charge sheeted in 2008 Malegaon blast case and is currently out on bail. So this legal bar applies only to individuals who have been convicted by a court. So conviction bars a person from contesting the elections, and this does not account for 100% or complete decriminalization of politics. So this is the current affair, and based on this we will understand what was the Supreme Court judgment, what was the background of the judgment, and what were the recommendations provided by the Supreme Court, and what should be the way ahead or what has to be done. But before we begin, this is our channel StudyIQ, and we are providing pen drive courses for various competitive examinations including SSC and bank courses, UPSC optionals, SSC JE courses, teaching examination, railway examination, defense examinations, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Services Examination, CLAT exams for various state PSCs, and also for various professional courses. You can visit our website www.studyiq.com for more details, or you can call to any of these numbers for more information. Let us first understand what was the September 2018 judgment of the Supreme Court. So in the September 2018 judgment, a 5-judge bench, a constitutional bench consisting of 5 judges of the Supreme Court, had looked into the matter of decriminalization of politics in India. So decriminalization essentially means that criminals are barred from contesting the elections. Now the definition of criminals has to be provided by the Supreme Court according to the petition or the application of the case. So the Supreme Court had to decide whether those people who are convicted of the offence is defined as a criminal, or those who are undergoing the trial are also considered as criminals, and therefore whether they should also be barred from contesting the elections. So this was the question before the Supreme Court in the 2018 September case, and here Supreme Court had to decide whether those who are undergoing trial were also to be considered as criminals and they should be barred from contesting the election. So a 5-judge constitution bench of the Supreme Court reviewed or looked into this matter, and the Supreme Court in this regard gave the verdict that the decriminalization of politics was not within the powers of the Supreme Court, or to disqualify the politicians who are undergoing the trial is not within the ambit of the Supreme Court. And in the 2018 September judgment, Supreme Court made it clear that to disqualify the politicians facing criminal cases from contesting the elections were outside the purview of the Supreme Court. Now we will look into the background at which the case had come to the Supreme Court. Several applications and petitions were filed by different people, different institutions in the Supreme Court, and which includes the NGO Public Interest Foundation, and the former Chief Election Commissioner J.M. Lingdo had also filed a petition before the Supreme Court regarding a Supreme Court verdict or a Supreme Court review of the matter of disqualifying the politicians facing criminal cases from contesting the elections. Also, Delhi BJP leader and lawyer Ashwini Kumar Upadhyay also filed a petition with the Supreme Court seeking for Supreme Court's view in this matter of disqualifying the politicians facing criminal cases or trial from contesting the elections. So this was the background at which Supreme Court had taken up this issue. Now some recommendations were given by the Supreme Court. Supreme Court, even though in its verdict made it very clear that it is not within the ambit and purview of the Supreme Court to disqualify politicians based on their criminal background from contesting the elections, it made it very clear that Parliament has to bring out a law that decriminalizes politics in India. So, Supreme Court said that it was within the purview of the Parliament or the legislature in order to legislate or make a law in the regard of disqualifying politicians from contesting elections, those who have a criminal background. So, it recommended that Parliament should bring out a strong law whereby it is mandatory for the political parties to revoke membership of persons against whom charges are framed in heinous and grievous offences. So, Supreme Court not only recommended to the Parliament to bring out a law that will decriminalize politics, but it also recommended that the political parties should take their own initiatives in order to revoke the membership of those persons against whom some charges are framed for any heinous or grievous offences, and they should be not allowed to contest in the elections to Lok Sabha or to the state legislative assembly. And in this regard, Supreme Court also mentioned that decriminalization of politics is very much necessary to achieve the constitutional democracy in India. Now, what is the way ahead or what has to be done? So, as per the Supreme Court guidelines, Parliament or the legislature should make a proper law or strong law or legislation that will decriminalize politics in India, and this law should address all the issues regarding decriminalization. For example, it should bar political leaders from contesting elections for those who are facing criminal trial, or it should also have provisions for revoking the membership of certain persons from the political party if they are facing any charges against any heinous or grievous offences. So, the legislation or the Parliament should abide by the guidelines given by the Supreme Court. But what really has happened is that the Parliament has not yet framed any such law. Even the draft law has not been framed, or no such law is introduced in the Parliament. This is because almost all the major political parties who have representation in the Parliament, in the Lok Sabha or the Rajya Sabha, have members from their party who are undergoing criminal trial in various cases. Now let us discuss a mains model question. The question is, criminalization of politics is a disease that will make our democracy hollow if left unchecked. Discuss the measures implemented to check the criminalization of politics and the effectiveness of those measures. So this is the question, and this topic, criminalization of politics or decriminalization of politics, is a very important topic from your UPSC GS paper 2 point of view. This comes under polity and constitution. So this is a very important topic. We will discuss this question and please try to attempt this question. So here the key words are criminalization of politics, again democracy, measures that are already implemented, and the effectiveness of those measures. So these are the 4 key points that you should keep in your mind while answering this question. Now you can begin your answer with an introduction, and in the introduction you can define what is criminalization of politics, and you can link this with democracy or democratic values, or how criminalization of politics is against the democratic values. So this can be your introduction. Now coming to the main content of your answer, you can discuss about the Supreme Court recommendations in this regard. You can also mention about the provisions under the RPA or the Representation of People's Act. You can mention about various measures that are implemented by the government, which includes nota. In order to improve the transparency, the candidates have to mention about their criminal records while filing the nomination. And you can also mention about the Law Commission report, which was asked by the Supreme Court on framing of false charges and submission of false affidavits by the candidates. And in the next paragraph, you should examine how far these measures have become successful. So you can here mention about the status of criminalization of politics in India. You can mention about the Law Commission observations in this regard. Also, you can mention about Supreme Court directives and whether these directives are implemented by the legislature or by the Parliament. So this can be your next paragraph. And in the last paragraph, you can give recommendations on improving the electoral democracy in the country and how to decriminalize politics in India. What can be the measures adopted? You can quote various recommendations from Law Commission, Election Commission, Supreme Court, and you can also add your own recommendations. So this should be the conclusion of your answer. This will give you a very good answer for this question. And please everyone try to attempt this question. Please post your answers on my Facebook page, or you can email me at joycey.studyiq@gmail.com. You can also follow my Facebook page for more video updates, and please write to me at joycey.studyiq@gmail.com for any of your queries or clarifications. Thank you so much.